Good morning and welcome everyone. We are here today to the webinar on intellectual property in Cambodia, Laos and Myanmar, hosted by Tilleke Gibbins in collaboration with the Australian Chamber of Commerce. My name is Alessia Monarca. I'm the Executive Director of OSCHAM Lao, and today I will be the moderator of the event. So let me introduce you straight away our speakers. We have Chandaya Ing and David Moll from Tilleke Gibbins Cambodia. Hi Chandaya, how David, welcome.
Good morning, welcome everyone.
And then we're gonna hear insights from Dino Santaniello from Laos, Tilleke Gibbins Laos office. Hello Dino. And yeah, Dino, I think your microphone.
I'm sorry for that. So I repeat, nice to meet you all and good morning, everybody.
Good morning, Dino. Last but not least, Yuvadi Tinarm from the Myanmar office. Hello, Yuvadi.
Hi, hello everyone. Good morning.
Good morning. So as we said, we are talking about intellectual properties today. So we know that IP rights protection can be often challenging, and there is a proliferation of counterfeit goods. But great steps has been taken in the years by the Cambodian, the Laos and the Myanmar government to strengthen the IP laws. And so I think we should start with our speaker and hear more from them on what are the steps that has been taken from the government and where are we with the IP laws and protection and rights protection at the moment. Let's start with Chandaya and David from Cambodia, and then we will hear more about Laos and Myanmar. Chandaya, David.
Thank you, Alicia. So today's presentation would begin, the agenda of today's talk would begin with the introduction to intellectual property, and then each country would take turn presenting about their respective country. They would cover four main parts. The first part would be about the overview of intellectual property regulatory framework. The second part would be about how to secure your intellectual property rights. And the third part would focus mainly on trademark, while the fourth part would be about the intellectual property right enforcement. To begin with, let me provide a brief introduction to intellectual property right in general. The global definition of intellectual property refers to the creation of human mind. That can be everything from works of art to inventions to computer programs, trademark, and other business signs. Quite different from real property like land and house, and also quite different from the tangible property like motorbike or car. Intellectual property is an intangible property of owner or creator because it's a creation or the fruit of a human intellectual. Just like other property rights, IP rights allow the creator or owners of the IP to benefit from their work or investment in the creation by giving them control over how his or her property is used. So it is just and appropriate for the owner because they might spend money, time, and energy in investing into the creation or innovation. So by providing them the IP right, it's like encouraging them for more commitment for further innovation and creation. So IP play an important role in the development of cultural and economic life. There are several different types of IP. Taking iPhone from Apple Inc. as an example, we can see that there are several IP lying under one single device. The shape and how things in position could be protected under industrial design, while the ringtone as well as the softcode can be protected under copyright. And then the large screen technology or the data processing method might be protected under patent and utility model certificate, and in some countries we call it as petty patent. And the Apple logo, of course, is under trademark, while there might be technical know-how that could be covered under trade secret for by Apple Inc. But why do we have to register IP? In general, you have to register IP right, and the biggest reason is, of course, ownership. Just like other property right, you need an ownership to prove that you own it. And with the ownership, you have the exclusive right, which is the right to exclude others from selling, making, or using your property. Moreover, it could also provide competitive advantage to yourself by being able to distinctively distinguish your product or service from others. It also adds the economic value to your business by by putting you in a better position for licensing and franchising. And in some countries like Laos, registered IP could be used as a collateral. Last but not least, registered and IP right will provide you a better protections and enforcement against third party. You wouldn't want to rebrand yourself or lose profit just because someone is trying to imitate you. Therefore, IP play an important role, and securing it at an early stage is really important. I might start with Cambodia first, and then the presentation will be provided by me and my colleague, Mr. David Moll, and he will be the last speaker for the first part of Cambodia, which is about enforcement of IP right. Just to provide a brief introduction about Cambodia regulatory framework, Cambodia is a party to several international conventions and treaties, such as the Paris Convention for Industrial Property, the TRIPS Agreement, the Madrid Protocol for International Trademark Registration, the Patent Cooperation Treaty, the Hague Agreement for Industrial Design International Registration System, and lastly, the Berne Convention that Cambodia has just ratified in late 2020. We are, of course, the member of WIPO and WTO. The things to highlight about the bilateral agreement that Cambodia is a party to is the commitment to facilitate the patent grant, in which Cambodia tried to make a cooperation treaty with several offices of other countries such as Singapore, China, Japan, South Korea, European Union, and the last one is the United States of America. So this bilateral agreement is meant to have the patent grant in Cambodia due to the lack of human resource in the field of patent and scientists. The main law in Cambodia is the law of trademark, and then the law on copyright, and the law on patent. The law on patent has been amended in 2017 after Cambodia joined the PCT, and to amend the provision relating to pharmaceutical patent protection as well. But how should we secure the IP right in Cambodia? First, you will need to understand what is your invention and what suits your invention or creation. Just like other countries, Cambodia protect patent, utility model certificate, which in some countries called PT patent, industrial design, and trademark, of course, copyright and related rights, geographical indication. IP right in Cambodia is territorial, so you need a registration in order to secure protection in Cambodia. So trademark, patent, utility model certificate, industrial design, geographical indication require registration in Cambodia if you want to have the right in Cambodia. Copyright and related right is more like exception because they are automatically protected. Although there is a voluntary registration system at the Department of Copyright and related right as well. One thing to note about copyright in Cambodia is that currently the automatic protection for foreign work is still under progress because Cambodia ratified the Berne Convention in late 2020. However, the law has not been amended, so we are still waiting for further regulation and implementation about automatic protection of foreign work. For the purpose of the presentation, I will only focus on patent, industrial design, and trademark. So let's start with patent. For patent, you can do the filing before the Department of Industrial Property, and there are several filing routes that you can choose, such as the PCT National Phase Entry, that you have 30-month deadline from the initial filing date for the filing. Otherwise, if you have Singapore granted patent or China granted patent, you can choose the re-registration system, which is more like an expediting process. And of course, European patent, if you have the European patent patent, you can do the validation system. And lastly, you can also do the local filing by claiming priority from the Paris Convention, which is 12 months from the filing date, and then use the other facilitating grants such as the Japan granted patent system or the Korean one. The definition of patent is the title granted to the invention, and in order for the invention to be patentable, it has to be new, involve inventive step, industrially applicable, and of course, it's not prohibited by law. It should be noted that in Cambodia, pharmaceutical patent is not protected until 2033. And the patent is protected for 20 years, subject to the payment of annuity fee. We also provide the official fee in the on the slide so that for your information as well. On to the industrial design. It's also under the Department of Industrial Property, but you can do two filing systems. The first one is the local filing, and then the second one is the international filing, which is filed through the Hague system. The definition of industrial design is any composition of lines or colors or any 3D forms or any material where there is a line or color, provided that those compositions give a special appearance to the product and it appeals to the eyes. And the requirement is that it has to be new. The protection is 5 years, and then you can renew for further consecutive period of 5 years. So it's like in total it should be 15 years. The official fee is also provided for your information. The last IP right to be presented is a trademark registration, and trademark is quite different from the other industrial property that have been presented. It's under the Department of Intellectual Property Right of the Ministry of Commerce. You can also choose two filing systems. The first one is the national filing, and the second one is international filing, which is the filing through the multi-protocol system at WIPO. Definition of mark is any visible sign capable of distinguishing the good or service of an enterprise. So it means that it can be a letter, signature, number, words, logos, or any combination of color. And to be able to be trademarked, you have to be able to distinguish yourself, or it's not identical to the prior registered map or well-known map. The most common obstacle that we have faced when filing trademark application in Cambodia is the first two, which is capable of distinguishing and not identical or similar to the prior map. Cambodia also follow the list classification that contains 45 classes. Class 1 to class 34 is for goods, and 35 to 45 is for services. Cambodia has a multiple class application system. However, we do not have divisional application. So that means if you one class of your multi-class application has been rejected or opposed, the other class will be delayed. So it's not really recommended to do multi-class application. For the registration for process, of course, you will start with the filing, and then it will go to the formality examination, in which the examiner will check if you have provided enough required documents such as original notarized POA or the form is completed correctly. And then it will go to the substantive examination, when they will check the registrability and availability of the map. If there is no obstacle, the map will go to the registration and publication. Then there will be a 90 days deadline from the date of publication for the opposition. The map is protected for 10 years and can be renewed indefinitely. It should be noted that you should file the affidavit of use and non-use between the 5th and the 6th anniversary of registration date. In case the map has been already renewed, such filing has to be filed between the 5th and 6th anniversary of the date of renewal. The map is vulnerable to non-use cancellation within 5 years from the registration when the registration is completed. Let's move on to David, and he will continue the floor for the enforcement of IP rights.
Thank you, Chandavia. So yes, if you have secured your intellectual property rights, as Chandavi just presented on, you can have cases where somebody is violating your intellectual property right. We call it violation or infringement of your intellectual property right. And when that happens, you can consider enforcing your rights against these parties. We will discuss some of the authorities in Cambodia, some of the measures you can take, and we will end the presentation with a few real-life cases that we handled in Cambodia to show that enforcement is definitely possible. We distinguish two types of authorities. We basically have the supervisory authorities, which are the authorities where you register your IP right, but in addition, they also provide you with an infringement opinion, so they can look if there's an infringement or not, and provide their official expert opinion. And they hold mediation procedures, so they have a dispute resolution procedure where you can go to settle your disputes as well. In addition to the supervisory authorities, you also have the pure enforcement authorities. The pure enforcement authorities are more akin to the police. In Cambodia, you have the Cambodia Counterfeit Committee, or the CCCC, which is basically a committee with representatives from 11 ministries. This means that you can submit a complaint to their secretariat, and the counterfeit as a committee will, the counterfeit committee will establish a team of experts to handle your complaint. So in case you have a copied medical device or your trademark is used on a medical device, they can involve the police to conduct investigations, but they could also include an expert from the Ministry of Health and look at the pharmaceutical laws. So the counterfeit committee is really a one-stop shop where you can submit a complaint and they will get the right expertise to handle your complaint. A second enforcement authority is the Anti-Intellectual Property Rights Crime Bureau, which is more a regular police enforcement authority. They will accept complaints, request a warrant from the prosecutor, and usually conduct a raid action to obtain evidence. And this evidence will be given to the prosecutor for criminal prosecution. There's several types of measures to enforce your IP rights in Cambodia, and we generally distinguish three main groups. The first group would be private enforcement measures. These are the measures you can take without the need to involve any of the authorities. So you as the rights holder could take these measures by yourself. The second step would be, or second group would be the administrative proceedings. This is mediation procedure led by the supervisory authority. So the supervisory authority where you get your protection, they have experts and they usually have a litigation office where they will handle a dispute resolution procedure or mediation for your dispute. The third group is civil or criminal action, and this is maybe the toughest measure you can take, which involves going to court, civil court, or filing a criminal complaint, where you file a victim complaint to the police or to the prosecutor, and the enforcement authority will enforce your rights if they accept the complaint. I will discuss each of the measures in more detail. So the measures, the private enforcement measures are taken by the rights holder. You don't need to involve any of the authorities, which means that you have more control over the case and you have more control over the costs. You're not giving away the enforcement action to an authority who can decide themselves what action to take. The measures we put under this group are usually letters, so there's different types of letters. They can be very strong, but also very cooperative. So we have the cease and desist letter, the warning letter, notice letter, and the cooperation request letter. In addition, you can also engage directly in negotiations with the other party to solve your infringement dispute. And another private enforcement measure would be takedown requests. So if you have e-commerce or social media platforms such as Alibaba or Facebook, they usually have a takedown request form which you can fill out as the rights holder, and if you evidence you have the correct registrations, they will remove the infringing content from their platform. So we would also put those under the private enforcement measures. These measures are very effective in Cambodia. Most infringers immediately reply to letters or to negotiations. So this is a recommended first measure in infringement cases. I think we can say almost 80% of the cases we have are solved at this stage. In case the private enforcement measures would not help, we sometimes recommend to go and do an administrative proceeding. Administrative proceeding is supervised by the supervisory authority, which are basically the experts on the particular IP right. They have a non-binding mediation procedure in which they invite both parties to discuss the dispute. The supervisory authority gives their feedback and might give orders, and both parties have to mediate and decide if they want to solve the dispute. If they do agree on the settlement or to solve the dispute, this agreement will be written in the signed minutes. So you actually have a written document that reflects the agreement between the both parties. And with having the supervisory authority oversee this mediation procedure, it is often very successful. Most infringers will comply because there's a government authority involved. However, as said, it's non-binding, so the other party may not follow the agreement, and in that case you have to take further action. But I think in most cases, especially straightforward infringement cases that were not solved by enforcement measures, this step will definitely solve your issues. The third group is civil or criminal action, and this is the most strong action you can consider in our view. The civil action would be filing a complaint to civil court. So you basically file a complaint and you request compensation for damages, but you may also request preliminary injunctions or final injunctions. Injunctions are basically orders by the court in which they order the other party to stop manufacturing or stop distributing. And these can be taken preliminary at the beginning of the court case, or they can be ordered at the end. In addition, you can always seek damages for your compensation, but we usually do not recommend this step because the court cases in Cambodia can be quite long, and IP knowledge is still limited in Cambodia. However, for big cases with big damages, we do recommend going to civil court. The criminal action is filing a criminal complaint. So you can file this at different levels. You can file it to the enforcement authorities such as the CCCC or to the police, but you can also file directly to the prosecutor. The prosecutor or the enforcement authority will review your complaint, and if they view that there is indeed an infringement of your rights, which is also an infringement of the trademark law or any of the other laws that are applicable, they can execute raids and seizures. So they will go to the location. Let's say there's a distributor that has a warehouse, they go to this location and seize the infringing products. This action will always lead to criminal prosecution. So if you file a criminal complaint, this always triggers criminal prosecution of the infringer, which means they could be subject to fines, but also imprisonment. You can always request the destruction of the counterfeit goods as well via the prosecutor or the court. However, in many cases, we opt for an out-of-court settlement where you do not go through the whole criminal trial, but you actually settle with the infringer for damages or for providing, for giving the counterfeit goods away. This is only recommended for the most serious of infringement cases, so we would say large sellers, importers, distributors, or manufacturers, because it's quite a tough measure for smaller sellers. So the enforcement authorities are usually not too happy if you come with a very small case to them. So we recommend this for the bigger cases. Yes, it's a strong step and it's usually somewhat costly. So that's why we recommend this for the serious cases. These are the penalties for trademark infringements under Cambodian law. In the table, you will see the two offenses. The offenses are counterfeiting or acts of unfair competition. Counterfeiting would be your product is copied as well as the trademark. Acts of unfair competition are somewhat different because it would more be an imitation of your product, but they might not use a trademark, or they pass off as being related to your company, but they do not necessarily use your trademark directly. So there's two different types of offenses and they have different penalties, as you may see. There are fines and imprisonment possible. Fines and imprisonment can both be applied to one single infringement. It depends on the judge. The offenses include the import, sale, offer for sale, stocking and manufacturing of either counterfeited or imitation goods. If you're a repeat offender, a judge may double the penalties, and damages are not subject to a limit. So the damages are based on actual damages that you can prove. In other countries, you might see that there's a limit or a percentage related to damages, but in Cambodia, it's basically unlimited as long as you can prove the damages. Now we move on to a few of the cases we handled in Cambodia. So this would be a private enforcement measure, which means that we send a letter to this infringer. On the left, you can see a coffee stall that says Star Cups Coffee and has a logo that is similar to a famous brand that is our client. I think you can guess which one it is. After sending a letter, the other party decided to change their branding. So on the right, we can see that Star Cups is now called Super Cups. And on the bottom right of the coffee stall, you see their branding has been changed. And they changed this at 4 different outlets in Phnom Penh. So this was basically sending a letter and negotiating with the infringer to stop. This is a similar case. We have a brand that looks somewhat similar like a famous brand again. But they would not respond to the private enforcement measure, so sending the CMD letter or the warning letter. So we had to take another step, and we went to the DIPR, the Department of Intellectual Property Rights, to undertake an administrative proceeding. In the proceeding, we submit the issues we have and how we would like to see it solved. And in the end, both parties agreed to change the logo that we deem problematic to the one on the right. So they removed the stars and the green color and the circles that were too much alike to that of our clients. So that would be an example of an administrative proceeding that was successful. And now we move into the more stronger cases, the criminal action. So in this case, there was our client was a manufacturer of audio equipment, and in Cambodia there was an importer selling counterfeits, but also a brand that looked very much like our client. So you can see JBL and JVZ. The JBL brand usually uses the same color orange. So our client was worried that consumers would confuse the 2 brands. We went to the Supervisory Authority, the DIPR, and they issued us an official opinion that JBL and JVZ are too similar, and that would be an infringement of the rights of JBL. So we submitted a complaint to the police authorities, and we submitted that official opinion as well. So that official opinion helped convince the prosecutor that also the JVZ products should be seized, not just the counterfeit JBLs. The police requested a warrant, and together with the prosecutor, they conducted a raid action. We can see here the police in the shop, inspecting the shop and trying to find counterfeit goods. And on the right, we see a bag of tags that you can add to a counterfeit. So this was a product, or these stickers were seized because they can be used to produce counterfeits. In this case, I think we settled for damages with compensation and dropped the criminal complaint, but all the counterfeit goods were seized for disruption. Another successful case based on trademark, but also an industrial design right infringement, is the case regarding motorcycles. So on the picture, you see 2 types of motorcycles. The right one is the one from our client, and the left is the one from the infringer. As you can see, they look very much alike, but the fake motorbike or the copy motorbike did not always use the trademarks of our client. So instead of relying only on the trademark, we also relied on the industrial design right that the client had. So the design of the motorbike and its shape were subject to an industrial design right and were protected. Again, we had to go to the Supervisory Authority to confirm that indeed this is a copy of an industrial design. And with this official infringement opinion that the motorbike is a copy of our client's motorbike, we went to the CCCC. The CCCC liaised with the prosecutor and convinced the prosecutor that these products are infringing the rights of our client and that they should be seized. In addition, we also noticed that some of the infringing motorbikes were bearing trademarks of our client, so they were also a trademark infringement. So in this case, we had to use 2 trademark rights, 2 IP rights, the trademark rights and industrial design right. And we had to rely on an act of unfair competition, on counterfeiting, but also the infringement of the industrial design right. The CCC took action combined with the prosecutor, and we were able to locate a warehouse with over 400 motorbikes. These were seized and the prosecutor settled the case with the infringer eventually, but we also found many stickers. So these are examples of some cases that are successful in Cambodia to show that indeed intellectual property rights are enforced and people do take their actions. So yeah, we recommend everyone that has investment or operates in Cambodian market or in any of the other markets that we will hear about later to consider registering your IP rights, but also taking enforcement actions because they are duly protected in these countries.
Thank you very much, Chandaya. Thank you, David. It's really good to hear your presentation and see that actually actions are taken when it comes to protect the IP rights. I will ask now Dino Santaniello to give his presentation on what is going on in Laos. Dino.
So, hi everybody. My name is Dino, and I'm the head of the Office of Tilleke Gibbins in Laos for now more than 4 years. And today, after my colleagues, I will speak about intellectual property in Laos specifically. So the agenda is more or less the same as my colleagues. So part one, just an overview of the intellectual property regulatory framework in Laos. Part two, we will know how to secure intellectual property in Laos, but again, like my colleagues, we will focus specifically maybe on few IPs such as patent, industrial design, but more importantly, trademarks, just because this is probably the most popular intellectual property to be registered in Laos to date. Then part three, trademark registration, and part four, we'll see also some example about intellectual property rights enforcement in Laos. So let's begin with the part one on the overview of the intellectual property regulatory framework. So actually, Laos has started to enact some laws and decrees about intellectual property and specifically about trademark very recently. It started all in 1995, and since that time, actually, Laos is trying to catch up a lot, and they've done a great work actually. So as you can see here, there are many international treaties to which Laos is a party, and these are the main one. Just to say that even though Laos is a landlocked country, might be isolated a little bit, but still the authorities are very active internationally, and they are very willing to try to catch up with international standard. Then here, like my colleagues introduced to us before, Laos is also part of bilateral agreements. So here you can see a few of them which concern more specifically patent. So these bilateral agreements actually allow people to register patent maybe in a more timely manner than they would if they didn't have registered such patent in those countries. So here like Singapore, Japan, China, but also there are some cooperation or bilateral agreement about some other type of intellectual property. So here I raised the example of the cooperation in the field of trademarks and geographical indication with Cambodia. So what does it mean exactly? So let's say a producer, and I will take the example of Scotch whiskey, for instance, which was registered very recently by our firm. Scotch whiskey was already registered in Cambodia. So we were able actually to more or less rely on the examination that was made by the Cambodian Intellectual Property Office, so that the Lao officer can maybe save some time in reviewing all the documents and grant the GI certificate in a more timely manner, which was the case actually. And Scotch whiskey was registered earlier December 2020, if I recall correctly, but very new. So here, as you can see, there are also some other bilateral agreements pending with South Korea, but patent, and Vietnam relating to new plant variety. So laws and regulation. Those who may be familiar with laws and regulation in Laos knows that there is often one law which is very general and maybe kind of difficult to actually implement or to enforce because it is very general, and then it comes with some other decision. That's what we call them in Lao language kotok long. So those decisions actually will provide more details and explain exactly how to implement the law. And here the law on intellectual property, which was is in effect since 2019, if I recall correctly, and it passed before the National Assembly in 2017. So below There are other decisions on trademark and trade names, new plant varieties, copyrights and related rights, geographical indication, and of course also it's good to mention that Laos is also a part of the Madrid Protocol for international registration regarding trademarks. And more recently, there were a decision on patent and petty patent, which was published in December 2020. And for industrial design, so we are still waiting for an update on this one also as well since the new law. But so far, up to date, the authorities will rely on the old one, but it is expected to be issued anytime soon. For the decision on patent and petty patent, I would like just to say that we may publish an article about this. So if you want to have more information on the novelties of that regulation, please feel free to let me know later. So here is just some figures about the filing of intellectual property in Laos. And here we are talking about filing, we're not talking about registration. So that's two different things. So here basically it's when one take an application to file a specific intellectual property, either a trademark, patent, petty patent, industrial design, or geographical indication. So as you can see, the numbers are pretty steady for trademark. For patent, it varies a lot from a year to another, but it shows also as well that people do actually file patent and trademark a lot in Laos, and usually we can see a big trend of trademark registration with one multinational, for instance, whenever they plan to actually invest or they plan to distribute their product in that market. So they will start to file trademarks in the first place and then start to distribute their products so that they know that it's very secured. So here we can see filing for trademark and trademark Madrid. So Madrid means the international registration, and I will just give a very brief overview on the possibility to do so. But basically it means that if you can register a trademark from a contracting member of the protocol, of the Madrid Protocol, to any other countries which are also a contracting member of the Protocol of Madrid. So let's move on to securing your intellectual property in Laos. So similar to Cambodia, actually. So here are the list of intellectual property which are protected in Laos. It's pretty much the same, trademarks and trade names, patents, petty patents, industrial design, copyrights and related rights, geographical indications, layout design and integrated circuits, plant varieties, and trade secret. I will not get back to the meaning of those intellectual properties. Chendavia earlier introduced the most prominent of them. But as you can see, the level of protection is actually the same as the one you've just seen in Cambodia. It's pretty much the same as the one you can see in other more maybe developed jurisdiction or with a regulatory framework which is more solid. So in terms of intellectual properties, we kind of cover exactly the same range of intellectual properties. So here again, I will take the example raised earlier by Cambodia. So you have intellectual properties that you would need to register. Otherwise, in order to enforce your rights or to enforce your intellectual property rights broadly, or to secure and to protect your investment may be very difficult. And on the other hand, you have registration, which is not required for some types of intellectual property. So here for registration required at first place, definitely trademarks, but I put a little star on that because for some trademarks, it may be not actually required to register your trademark, but this will concern only well-known mark, those very big brands which everybody knows. So those big brands and those marks known worldwide may not need to be protected, but it's very difficult to actually be able to single out what is a well-known mark or not, because there is no list. So it may be not very cautious if you start from the principle that your mark is actually a well-known mark in Laos, so that you will be fully protected. And then patent, industrial design, geographical indication, layout design of integrated circuits and plant varieties are also IP intellectual properties that you need to register. For some of them, like layout design of integrated circuits, I don't think there was any any application file in this respect as yet, but this is something possible. And on the other side, here you can see a registration which is not required, and this concerns copyrights and related rights. So basically a song or any artistic intellectual property most likely will not be required to actually register. But if you want to add some kind of another layer of degree of proof of protection, just to be sure that if someone infringes your right, you have the proof that you were the one to actually have created that intellectual property first. So you can file a notification with the Department of Intellectual Property of Laos. That's something that is possible. And then trade secrets. So trade secrets, you do not need to actually register it with the Department of Intellectual Property to be protected, and it's protected indefinitely as long as it's secret, and or more precisely, as long as not too many people knows that secret. So here a quick focus on patent and petty patent. So here, so where to file? So here the application must be filed actually with the Department of Intellectual Property in Laos. You may be able to use what we call a fastest route. Here I raised the example of the re-registration program with Singapore and China, but also with the Cooperation for Facilitating Patent Growth with Japan. So basically, if you already have a patent registered in one of those countries, the registration will move way faster. What is the eligibility for a patent in Laos? So invention must be new, inventive step, and something that we can actually use also as well. The time frame is pretty long, 48 months, but it may be faster if you file an application through one of the patent and petty patent fastest routes, as I just mentioned. And I didn't, just before we've seen the number of filing, but definitely the number of registered patent and petty patent in Laos is still pretty low because it takes a long time to actually get to obtain the certificate. Term of protection is 20 years and may not be renewed, and official fee is $150, but this concerns only at the time of the filing. There may be other additional official fees thereafter. Industrial design, so here registration must be made before the Department of Intellectual Property of Laos. And for your information and those living in Laos, you have the Department of Intellectual Property of Laos in Vientiane capital, but you may also have departments in all the provinces of Laos where you could actually file also your application there. And they may probably anyway transfer the application to the central level at Vientiane capital. So for the definition is pretty straightforward. A form of shell product to be created, which includes a shape, pattern, line, color. So it could be very various. Eligibility for industrial design must be new, not disclosed to the public, and must be something ornamental that gives a special appearance to the object. Time frame 6 to 12 months. It really depends. And again, here there is a process is faster. This patent has been granted in countries where Laos is MOU, but as far as I know, there is not yet. So I'm sorry for this, but it may be coming actually. I may be able to update you on other pending MOUs regarding industrial design. Term of protection, 15 years, and official fee at the time of the filing will be $54. So now let's move on to trademark registration, which I guess is the type of intellectual property that interests most of the audience today. So here for trademarks, two ways to actually file a trademark in Laos. So what we call a national filing is just exactly what I've said before. You need to go to take your application. You need to submit the application before the Department of Intellectual Property of Laos in Vientiane capital or in one of the related departments in one of the provinces of Laos. And also another thing to say about it, there is no yet e-filing in Laos. So I think that's the case in some other ASEAN countries, but not yet for Laos. They are in preparation though, so it may happen anytime this year. There may be an announcement from the Department of Intellectual Property of Laos that will allow people to actually file a trademark through internet and through the website of the DIP, as we call it in Laos. So if you want to have any updates on this, please do feel free to let me know, but you may hear about this hopefully soon before long. And then there is also the possibility to file an international registration. So here, people are often mistaken that they could directly file an international trademark in the first place, and then just choose maybe over 100 countries, so they can protect their trademark in more than 100 countries. But it's misleading. First of all, in order to have an international trademark, you need to go before the national filing. And after that, when you are granted with a national filing, you may be able to kind of convert your application into an international registration. And from that, you may even go from the World Intellectual Property Organization website and file a trademark in countries which are also a member of the protocol, of the Madrid Protocol. But beware that it may be very easy to actually file, but if there is a problem that happens to your registration at the time you choose maybe more than 10 or 20 or 50 countries, you will have to actually respond to those, what we call office action, from each national intellectual property office, and you will need to rely on a local lawyer or IP agent in this regard. So at first you may think it's pretty easy and very efficient. It is, but you must be sure first that your trademark is actually available in all the countries you want to submit the application to. For trademarks, so here a brief definition, it can include personal names, letters, numerals, figurative elements, 3D image, motion, animated pictures, whatever. It could be a logo or wordmark. That's something you can definitely register in Laos. And here 3D motion animated pictures, that's something new since the new law on intellectual property. But I think to date it's pretty difficult to be able to register these, just because my opinion is that the Department of Intellectual Property are not yet the proper tool to do so, but it may come soon. Anyway, it's good to see that the Lao authority is trying to keep up again with what we call unconventional trademark. Class, so same as Cambodia, 45 classes. So here classes is at the time you will register your mark, you need to kind of connect your mark to a type of good or service, actually, and your mark will be related to that type of good or service. Okay, so let's say you register a trademark for a car, for instance. You will be able to protect your trademark for people infringing your trademark about cars only. If they use the trademark for another type of purpose, I don't know, selling fruit and vegetables, you may not actually trigger an action against that trademark owner because he has the same trademark as you. The class is very different. So, and save for some exemption, usually you will be able to protect your mark related to the class you're registering your mark to. And Laos has a multiple class system, which means that at the time you actually file your application for trademark registration, you can choose more than one class. Eligibility, pretty much the same as Cambodia, must not be identical to previously registered trademark, not descriptive, deceptive, not generic words also as well, and does not contain prohibited items. So here we need to check on what the law called prohibited items. It can be very wide. There is a big range, wide range of things that may be called prohibited items. But let's say things that go against the fine tradition of the country or against the moral, for instance, or whenever you use the name of political leaders, definitely that would be something that cannot be used to register a trademark. Here the registration, so similar as Cambodia, almost. I think there is one thing that is different, and which is pretty new since the new law on intellectual property. So first of all, you start with the filing, which is very easy. You have to take a form from the Department of Intellectual Property, say exactly what you want to register, which class. Is it a logo, a wordmark? You need to file also a specimen of the logo you want to file. And then we'll start the formality examination. So here it's very basic examination just to check on what type of documents you have submitted to the authorities and if those documents are actually correct. If those documents are actually correct, then we go to the next phase, which is the publication. And this is a new one and very important because at this time, the Department of Intellectual Property will publish the application you have submitted to an intellectual property gazette, which is available online. And here, third parties like you and me can consult that gazette and actually oppose to any trademark registration if you believe that the trademark, the pending trademark registration is actually infringing your rights. When the publication process is actually over, then we move to the substantive examination. And here it's more to check whether or not the mark is actually already registered or similar to another mark which is already registered or contains those prohibited items I just mentioned. And after that, there will be the granting of the certificate. So here, just to maybe summarize briefly, time frame to complete the registration. So there is no time frame according to the Laos law or the decision on trademarks, but from our experience, it's 12 to 16 months for a straightforward process, which means that, for instance, nobody has opposed any opposition to your registration. Terms of protection, 10 years renewable, and official fee, $110 for one trademark and one class, or if you add additional class, then it will be $90 from the second class onwards. So here, be minded that it's US dollar. So when we convert to local currency, it may be a little bit different, but this is, I believe, more or less what is there in US dollar as of today. And here again, you can also file a cancellation. Even if a trademark is registered, it doesn't mean you cannot actually cancel that trademark if it infringes rights. So here, for instance, there is the non-use concept, which means that if one doesn't use the trademark at all, then a third party can actually ask for the trademark to be canceled so that they can register it. So here it's an example of a certificate, a little bit old. I think now they have some kind of a little bit different, but it's more or less the same actually. So basically you receive that type of that piece of paper from the intellectual property that can be used whenever you want to actually enforce your rights, as we will see now. So measure to protect IP rights. I would say there is those measures: cease and desist letter, civil or criminal action, administrative remedy, and redaction. Kind of similar to what Cambodia actually has also as well, but we will see that in deeper detail now. So here are the main authorities regarding intellectual property in Laos. I'm looking at the time at the same time. Okay, so the main one definitely will be the Department of Intellectual Property, and then the Ministry of Science, which is actually the Department of Intellectual Property is the one that registers every type of intellectual property in Laos. They are not really much the one authority to enforce the rights, but they will act as a support most of the time because they have also the power to give an opinion on the infringement. So it's possible to actually ask the Department of Intellectual Property if you discover some what you think infringements of your rights, to know what they think about it. Then you have the Internal Trade Department from the Ministry of Industry and Commerce. So here it's authorities who are involved in consumer protection. So they are very active also as well in enforcing IP rights. Economic Police and the Customs Department, which has a specific task to actually stop the goods from entering or exiting from Laos. So as Cambodia, we could say that there are private measures enforcement. So first, those measures are very effective, and it's very convenient to use. So it's just a letter, well drafted usually, not much packed of legal terms or to threaten people. We try to avoid that, because most of the time in Laos what we notice is that people doesn't even know they're actually infringing rights, and they don't even know about the intellectual property law. So you can take a kind of a friendly approach depending on the type of infringement you observe and whether or not that infringer is actually someone doing it on a regular basis. But what we've seen is that it's actually very effective, and most of the time we will have, as David mentioned before for Cambodia, the infringer calling us immediately and ask us what are the reasons for that. So then we explain, and most of the time it goes very, very well. Then you have also takedown requests for which concern e-commerce and social platform, but most even broadly everything which is about internet. And negotiation with the infringer. So negotiation with the infringer can actually happen after the cease and desist letter, where the infringer may want to use the trademark, the mark correctly, and even seal a deal with our client. So this is definitely the measures we recommend to start whenever you want to take any action for intellectual property infringement. Administrative remedy is very also useful. So first we can talk about the mediation process, which can be triggered by the Ministry of Industry and Commerce, but most likely the Department of Intellectual Property, because they will have an approach very specific to trademark, and they may be able, I think, to lead the mediation pretty well. We've done some of them, and it was very effective. And also the good thing is that at the end of the day, if there is an agreement, the agreement can actually be signed by the parties, but under the supervision of an administrative authority, which means a lot actually in Laos. And then you can also ask for redactions if your first move to try to stop the infringement didn't work. You can file also a complaint with some of the authorities, either the Ministry of Industry and Commerce, for instance, to try to stop and seize counterfeit goods, what you deem counterfeit. But most likely, I think that's something we've noticed, the Ministry of Industry and Commerce will want maybe to have some supporting opinion from the Department of Intellectual Property in this regard. Then civil or criminal action is something definitely possible in Laos, but really not used. And we encourage actually to do so, because as long as we don't have any precedent, very important precedent at the court level, it's very difficult to talk about a trend before the court of law. So far there are some criminal action more likely actually filed with the police or the prosecutor, which has resulted in fines with and even imprisonment with some infringers. And here also what can be done from the economic policies redactions, and they can seize counterfeit goods and also proceed with the destruction of them. Sanctions. So as you can see here, there is a wide range of sanctions, and the sanction will be more or less heavier if the entity infringing the intellectual property rights was actually someone doing it on a regular basis or not. If not, most of the time there will be some kind of a memorandum between the infringer and the authorities, and the infringer just swear that they will not do it again before they got actually sanctioned as per the articles here. So here, just one study case, 3 studies case. I would be very brief, running out of time now. So here it's for one of our clients, actually from Scotland, Scotch whiskey, which has registered its GI now since December. And you may have seen in Laos some whiskey using actually the term Scotch whiskey, which is prohibited. So here what we've done is actually we sent a cease and desist letter to the infringer, and the infringer was very understanding and just stopped and make sure that all the goods are bearing the Scotch whiskey term are not to be sold anymore. Same thing actually for another one of our clients for the unauthorized use of a trademark. So here again, we wrote to the supermarket based in Vientiane capital, and we were able actually to stop the infringement also as well. So everything started from private enforcement measures, and it was very, very effective. It didn't last long before actually the infringer stopped the infringement. And finally here, another case where I think it was led in the south of Laos, as it's actually written on the slide. And here we did file a complaint with the Ministry of Industry and Commerce, and we're able actually to seize goods. Here you may not see a lot, but there was a lot, that maybe more than 1,000 of products were seized during that time. So I think that's about it. It was a very brief overview of the intellectual property framework in Laos and the way you can enforce your rights. I hope it was clear for you, but if you have any questions, please do feel free to let me know anytime.
Let's go to Myanmar. So Yuvadi, it's time for your presentation. Thank you very much.
Okay, everyone. Good morning. Before I present my presentation on about the overview of the intellectual properties right and key point of Myanmar new trademark law, I would like to start my part about as you all may know about the current situation of Myanmar is under the state of the emergencies, as you may know. I received many inquiry from our clients. What will be happen about the trademark filings and any others IP developing in Myanmar, any conditions or any disturbing about current situations for Myanmar filings, because as you all may know that this is a transitional period from the old system to the new system. I would like to inform you that all the system is still operating as usual. Any one of you that interested to file the trademark under the new system via online filings, and also the person who want to file the declaration of ownership, the Office of Registration of this still accept for the declaration for registration under the old system. And also for online filing for the new trademark laws, you still can file via online filings for the trademark that already registered under the old system or used in Myanmar. It seems like there have no any other condition under this period. However, the situation will be affected about the implementation of the new laws or new IP laws or any other for the grand opening period. We need to wait and see for the further announcement from the Ministry of Commerce or the Intellectual Property Department, which is the department that handling about these matters. But from now on, we don't have any further notice to stop for the filings, and we understanding everything will run and operating as usual because this law is important for Myanmar. Okay, let me start for my presentations. This scope or my agenda in this time, I will focus on the new law only. I will provide some information and additional information about the old system a little bit for supporting my presentation for you more understanding about the current system in Myanmar. However, the most important that I would like to point out about the new law, especially like the other office, the trademark right under the new trademark law in Myanmar. Okay, let me start for the overview. As you may know that the patent law of Myanmar is already enacted in March 11, 2019. However, this law is not still enforced or implemented yet because we need to wait for the patent rule and regulations. And also in the law also mentioned that about the application for the patents about the pharmaceutical will be start, in later stage because it's more complicated and they need to prepare the team or examiners to support for these matters. Under the patent law, the patentable is need to be novel and involve an inventive step, and also is industrially applicable. For the patent is valid for 20 years from the filing date. However, for the petty patent, it's just only 10 years for the protections. However, the annuity fees need to pay as annuities. And also, if they have anything infringement, they have the criminal penalty for these matters for the person who infringe the patents in Myanmar as well. Another law is about industrial design laws. This law is implemented on January 30th, 2019. This the same date with the trademark law. This industrial design must be novel in domestically and internationally. It should not be disclosed or exhibit to the public in any countries and free of limitations in any country as well. The protections for the industrial design is 5 years. However, we can renew twice time for each 5 years, in totally for 15 years in total. The same, we can take the legal actions against the person who infringed the industrial design. They also have the law. This case must be take the action and file to the intellectual property court that are under exhibit based on this law. Another law that interesting is about copyright law in Myanmar. Actually, Myanmar already have the copyright law in 1914, but that law is quite old and reserve the right only the Myanmar inventions and produce and create only in Myanmar only. However, the new copyright law was the latest IP law in Myanmar that enacted in May 24, 2019. This law is allow for the non-citizen or non-resident can be protect their copyright in Myanmar, but they need to have the first published in Myanmar or published in Myanmar within 30 days. This is the one. However, for the copyright that already registered under the Berne Conventions, as Myanmar is not yet signatory for the Berne Convention, that's why the copyright that already under that conventions cannot be protected under Myanmar yet. We need to look and see what will be the next step for their IP department to be considered and when they will consider to implement for this part. And normally for the copyright in literally and artistic works, it will protect for the whole life of that person. And then after 50 years, after that person is damaged, 50 years as well. And for other work, it's about audio, visual work or other film. It will be protect only 50 years from the date that published the first publication. And also the same as other law, the person who have infringed on copy and unauthorized to use the copyright, that we can take the actions under the law, under this law, and also have the penalties. The court can have the issue the penalty by fine or the something like have to imprisonment as well. Okay, this is the last one about the trademark law. The trademark law is only one now that start to be in the process. Why I said like this? Because Currently, that we call about soft opening periods. It means the period that the IP department is allowed for only the trademark owner who already registered under the old system by filing or register declaration of ownership or an actually used in Myanmar. This is based on the Section 93 of the Trademark Law. This soft opening period already established and start since October 1st, 2020. Initially, they plan and expect that it will be around 6 months. From October, it means this soft opening period will be end by March 2021. I mean, next month. However, there is no any officials that this is the end of the soft opening period will end by the March. That's why we need to wait and see for the official announcement by the IP departments and also any further condition that may be affect. We need to look and see. For us, we need to keep an update for you if they have anything changed under the current situations. Okay, that I already mentioned about the soft opening period. Some of you may think, what is the privilege for the person who filed the trademark under the soft opening period? Because Myanmar will change the system. Under the old system, the person who have the priority use will have the priority right under the law based on that use. However, the new system that will change the system in the reward. It means that the person who filed the trademark under the new trademark law, they will have the priority right based on the filing date. How the importance of the soft opening period date? Because all the trademark that filed during the soft opening period will receive the same filing date. That is the first date that they're opening as the grand opening to accept for all trademark. For example, if the IP office announced for the 1st of March is the grand opening period, all the trademark that already filed under the soft opening period will receive the 1st March at the application date. That's why this group of trademark will be the priority right based on the filing date over the other trademark that will be assigned for another date based on the filing date. This is the one. We have another further update for the person who already filed the trademark under the soft opening period, because the IP department has arranged the workshop on December 29th and update about some informations. They mentioned that the person who already filed the series mark, the series mark is the mark that combine more than one mark that maybe is different color or different combination, but include with more than one marks. That series mark is not allowed to file under the new trademark law. And otherwise, for the trademark that already filed as an error or any mistaking, or they have some further instruction from the client that they will no longer require to file that trademark, we still can file the withdrawals of the application without any further additional cost to pay. However, if you have some minor amendment and don't want to withdraw that trademark, because each trademark will assign the application number, you want to reserve the priority application number, you can do it, but they will announce later after the official implements, and then you need to pay for any official fee at that time. That's why you may need to consider which one that you prefer, with fee or no official fee. However, please know that any application under the soft opening period will have the same filing date. That's why that issue may not be the priority concern. One of you may ask me about when the official fee will be issued or announced by the IP departments. Actually, the official fee is still pending, and they plan to issue letters because they want to see the system is still stable and maintained, and then they will consider. And as I know, they already discussed with online payment via the banks, maybe by the MPU or credit card. We need to look and see in the near futures. Any other concern about the soft opening periods? Please note that the soft opening period or application is not allowed to do any amendment or any addition. For example, the list of goods or amend about the marks, because it's their register may consider as this is the new mark that ask you to file under the grand opening period, or after that maybe you cannot reserve the first filing date. This is the one that we need to see from the official guideline for the futures. But this is the one that they already include and their notification in August. That's why we need to strictly follow, because if not, your application will be delayed for the examinations. Please also another note, we have informed that all the trademark that file under the soft opening period will be examined again, because as you know, the old system that don't have examination procedures, the new law are required to examine your trademark that file under the soft opening period. If your trademark is descriptive or non-distinctive or some generic word, the IP office suggests that you need to be disclaimed to avoid any delay for their review and examinations. This is the suggestion. However, if you can prove that that generic word or descriptive word you use for a long time and people already know or well known in Myanmar, you need to provide support, the documents to prove that your trademark is strong enough to register in Myanmar. Okay, the next one I will inform you about what is the new system of the new trademark law in Myanmar. This is governance structures. Okay, now the IP system, we received an update that now they are in the fourth step. They already established the intellectual property departments, and now they are under the recruitment of register and examiners. This is the one that we need to look and see if they can complete soon. It means the law and regulations will be followed, and it's no longer for the IP department can start for the grand opening period. Okay, this is the definitions. I will focus on the definition about the marks under the trademark law in Myanmar. The marks in Myanmar is about the visible sign, include own name, alphabet, number, geographical representation, composition of colors, and other combinations of the sign. If you can see that this is a distinguished good and service from others that you can use and register in Myanmar. This is very short summary about the filing procedures in Myanmar. After you file an application, then the register will examinations. If they have any amendment, you need to submit within 30 days. If your pass of the examination is mean accept, your trademark will be published in the Trademark Gazette that we assume that it will be in online. And then after that, if nobody file the opposition during your publication in Trademark Gazette 60 days, your trademark will be registered. And then this trademark can be renewable in every 10 years. However, if other person oppose your trademark, you need to file the response. If you won the case, your trademark will be registered and then you can renew. If not, you can appeal to the committees within 60 days for their considerations. And then if you fail again, you can appeal to the IP court within 90 days. This is the process that like the circle for I think this is like the international practice. This is the futures for the trademark. Even you used to register under the old system, it doesn't mean your trademark can be registered directly, but you need to go under the examination. As I already mentioned, the trademark term is 10 years from the date of the application. For example, the date of the application for you is 1st of March 2021. That is the date of the registration date. Even the trademark of you is still under the examination, but your protection will be back until the 1st of filing date of your trademark. This is to protect your right from the beginning that you're filing the trademark. About the trademark assignment, is this like other country? The new system and the new law is allow you to assign the trademark during the process of the application and also after register that trademark as well. Licensing. It's not clear under the old system that the licensing need to be registered or not, but the old system mostly will be go by the parties and go to stamp duty and reference like normal or usual agreements. And for this licensing, if each trademark would like to license, that license need to be recorded to the IP department, and then you can refer and use this license. The cancellation is not the same period with Laos because Myanmar is just only 3 years. If you have other third party or any interested party can use the right to file the cancellation of the register mark if that trademark no use for 3 years since the beginning. If you first 3 years, for example, you register the trademark for the 1st March of 2021 until 1st of March 2024, you did not use this trademark. Any other interested person can file based on non-use. And also, they have more specific than that. If some same trademark owner can file the cancellation of the list of goods that you did not use in Myanmar. For example, I register my trademark for motorcycle and another one, and also register for restaurant. But I have never used for the restaurant, but other person they use for the restaurant, they can file the cancellation for a specific list of goods as well. Geographical indications. This is a very interesting for Myanmar because they have many products that can prove for GI in Myanmar, and also, for example, Tanaka, Shumeno, and these geographical indications, based on our attended workshop, they said that this will be another later step after they fully implement of the trademark, and then they can allow to register GI. The interesting one is about trade name. This trade name is not mandatory to register. However, if any person or any unauthorized person use that name with contradict to the public orders or public moralities, or make any damage for that person who original use for the trade name. The person who own that trade name have the right to protect that trade name in Myanmar based on unauthorized to use that name. About the custom department, as I know now, the custom department try to set up the IP department under their department that with current system, and then we need to look and wait and see for the regulation under the trademark law for the custom department. It is interesting that the custom department will not apply or take the seed action for any product that fakes or import by other rule regulations that specific that not take the actions. And then some fake product may be import into Myanmar for personal use and not for the commercial purpose. This one may be considered as the, even it's fake, maybe it may consider not to seed and take the action by custom department. We need to see what is the actual rule regulation that will be followed by the custom department on these matters. Okay, this is the offense and penalties for the infringers who want to try to counterfeit marks, using counterfeit mark on the good or service, and other processing any equipment mainly used for making a counterfeit product. This is the one that are trade and dispute. They have the penalty for imprisonment and also fine. And they also have the special clause for the person or in any infringers who do the same offense. I mean, if you have the infringers who trade or counterfeit or using counterfeit marks, they are arrested and go in imprisonment and fine one time. If they do it again, the penalties will be double. This is the cause that they try to avoid any repeating and also don't want to have any person to do it again, because if they try to do it again and they can compensate and they can accept for any fine, it means that and no any further double penalty, any person can do it the same way. That's why this trademark law is also mentioned about the person who is convicted again for the any infringement matters in Myanmar. The same, the case that need to go to the IP court that are under the establishment, and we need to look and see when the court issue their rule, regulation, and law to support for the futures Myanmar IP enforcement, and we need to look and see what is will be happens about Myanmar. And I hope that Myanmar can run and operate and protect the trademark, not only about others IP, but I hope everything will go smoothly. Thank you very much.
Thank you very much, Yuwadi, for your presentation. That was really exhaustive, and I think now is the moment for the Q&A. So we already collected a series of questions from the attendees, and I will start through it. Then again, if you have any other question, please let us know. I will start from a question for Dino in Laos. So Kamontik from Home Product Center is asking if you are producing products only for export, do I have to register a trademark on my name as well? Yuwadi, do you want to answer this question? How about in Cambodia? Sorry, Myanmar.
Okay, thank you. I think it's for the export product. For Myanmar, if you produce and manufactures their products and intend to only export to Myanmar, out to Myanmar, it is not mandatory, but we would suggest you to register in Myanmar because some of country, when you export, they may ask you to prove the original production or the original produce for the trademark certificate or trademark registration. At that time, you maybe need to show them, and also to avoid any other person to use and register, because you produce in Myanmar. If you not reserve your trademark in Myanmar, any person may see and use and register, and they take action for your manufacturing. This is the one that's my suggestion for Myanmar.
No, you don't have to actually register your trademark under your name or your company's name in order to export. It's not a requirement to export any kind of product, but just as mentioned, the problem may happen actually in the country where you're exporting your trademark to. If it becomes popular, then people may start to actually copy it, and you may not have any legal protection for that. Same thing for Laos, actually. I mean, people in Laos may want to copy your trademark, and even though you're the one to actually to have invested in the product, to have done the marketing and everything of the trademark, someone could just steal your name, and it would be maybe difficult for you to get your name, the name of the product back. So in any case, if you want to actually distribute, commercialize your product, we suggest you to register the product in the country of origin, and then also in the country where the product will be actually distributed, at least.
Okay, thank you. Thank you for the answer. This is for Chanday and David. What is the difference between the patent and the trade secret, and how is it protected by law in Cambodia? This is from Siri Shokirata, Royal University of Law.
So thank you for the questions. Actually, the difference between patent and trade secret would be on what suits your creation or invention and how the protection is provided from these two types of IP. So what suits your invention? So in case it is the invention such as mobile phone or computer, it should be under patent, while trade secret is more like secret information that could be a formula or a process or business information that have the commercial value if you keep it secret. For example, like Google search algorithm or Coca-Cola ingredients. And the difference of protection that provided by these two types is that patent would be protected for 20 years from the date of filing, and then in exchange of this protection, you have to provide your invention and disclose it to the public, so everyone will know about your invention. And therefore, it means that if your invention requires someone to know how it's works, patent should be preferred. But for trade secret, it's more like the protection is like as long as you can keep it secret. So it's only suited for those information that can be kept confidential. And you have to have internal measure to make sure that your secret is kept. And those internal measures can be like non-disclosure agreement, or so on and so forth. Also, it should be noted that in Cambodia, we don't have a trade secret law or the law that protect undisclosed information yet. And mostly, those type of information is protected under different law. For example, the non-disclosure agreement can be protected, of the employment can be protected under contract law. Yeah. Do you have anything to add?
No.
Okay.
Okay, perfect. So we are running out of time, but there is, I think we got 2 questions from a live event Q&A, so I think maybe we can go quickly through it. So for Yuwadi, if IP is registered in Cambodia, can the law be enforced if IP is copied in another country? Yes.
So if IP is protected in Cambodia, it will not be protected in other countries. However, there is some provision in other countries that provide protection for well-known mark, something like this, so it can be protected. But actually, IP is territorial right. So you have to make sure that you have your right registered in each respective country that you want to be protected.
Okay. Okay.
Yes.
Dino, this is for you, but actually for all of you. I'll start with you. An anonymous having asked if you have experience protecting unconventional IP of these three countries against infringements from third parties. For instance, protecting textile design of the ethnic groups of Myanmar, Laos, or Cambodia, like Hmong or Akha, against infringement from fashion companies in Europe?
Okay, so I will start first. Do we have experience in protecting textile? Yes, actually, but it was not under trademark, it was under copyrights. And usually that would be something that fit better. Now, it is not prohibited to actually register a motif on a textile as a trademark also as well, and it could be a good way also to even enhance the protection of the design of the textile. But I would say in the first place, I would think more about copyright. So then the problem would be to prove who was the first person to actually having produced or to having made the design that is subject to the dispute. But yes, we did actually represent some people in protected design on textile relating to Lao ethnic.
Okay, that's interesting. Does any of you has anything else to add to this question? Yuadi, Chandaya, David, do you have any experience you want to share? No. Okay, we leave it with Dino.
Okay.
Thank you. Yeah.
Okay, smile. Okay. Okay.
Yes.
For Myanmar, we don't have the case for about textile. What we have the case about in related to the Myanmar art about the traditional sport. It's not similar, but about the design of the Myanmar traditional sport style, like drawing, something like that. Because Myanmar is protects only the for the copyright, because trademark we cannot take much action for this matter, because as you know we are under the transitional period, and also the only one law, that copyright law, that only protects for the Myanmar. But they also don't have any government officials, I mean, or the committee to be review or filings any applications on these matters. The thing that we try to solve is this gap between about national sport and also the private sectors. We try to make the negotiation for compromise the situations. What is the federal sport for that, who own that sport style, and also about the private sectors, how to make the good cooperation to each others. Maybe the private sector can do some support for the federal sport, something, and allow to use something for that, for their screen of the product, something like that. It's a bit, because I can not disclose.
Sure.
Yes,
absolutely. No, thank you very much for the feedback. I think for today is pretty much everything. We had a very interesting session on intellectual property. We will come back with you, all of you. We'll come out with a new communication for the next webinar on legal series, hosted with Tilleke and Gibbins. Thank you very much to our speakers for being with us today, and thank you very much to all of you for participating to this webinar. And I wish you all a nice day ahead and a nice week. I'll see you soon.
Thank you.
Thank you very much.